Welcome back to UK Knowledge Guru. In this video, we will answer the question, how many days can I live outside the UK and still work remotely if I am on skilled worker visa in order to get indefinite leave to remain? We will also find the answers to the following questions. What is the ILR time count rule if you have secondary employment? Will short visit outside the UK, for example, you are on holidays, will affect your ILR 5-year residence requirement? To find these answers, we will refer to the official UK government website gov.uk, the only genuine authentic website which I always say you should trust. So we will go on gov.uk, and in the search section, we can write or we can go down and look for the visa and immigrations. When you will click on it, it will take you to the option where you will look for live permanently in the UK. Click on that. After that, check if you can get ILR, indefinite leave to remain. This will take you to the option check if you can get ILR. Then at the bottom, look for tier 2 skilled worker visa. Click on that. Indefinite leave to remain if you have a skilled worker, health or care worker, tier 2 or tier 2 visa. Then click on the time in the UK. This will take you to another option which will have indefinite leave to remain if you have skilled worker, healthcare, tier 2 visa immigration. And now this will tell you the time in the UK. So according to this guidance, you must have lived in the UK for 5 years before you can apply ILR. There are rules for what counts towards 5 years. Spend time outside the UK, had more than one visa. If you have spent time outside the UK, you must have spent no more than 180 days outside the UK in any 12 months. Later on in this video, we will look the guidance and we will explain you what further this means. If you think you are affected by this rule, then you can check the calculate your time. You can do that. If you had more than one visa, then these are the visas. If in the 5 years, if you have lived in the UK, you can include time you have had any combination of the following visa. So many applicants ask me, I have spent time on skilled worker dependent visa and then I have switched on the skilled worker visa. Will my time will be calculated, or I have spent time on graduate visa? Now where they get confused. So graduate entrepreneur was the different visa category. We don't do that anymore. Applicants who are in the country, they are the only ones. We don't do that. Like we don't issue that anymore. So skilled worker. So if you have spent time on skilled worker visa, healthcare worker visa, scale up worker visa, tier 2 minister of religion, international sports person, innovator founder, global talent representative of an overseas, only these visa, if you have spent time, that will be included. Otherwise it won't be included. So if you have spent time on graduate route, it won't be included. In order to know more about this, we will click calculate your time in the UK. As soon as you will click this link, it will take you to the guidance page. Finding this guidance is very difficult. Reason because of the name. The guidance title is calculating continuous lawful period. And whenever you look for ILR time calculation, this won't open. At the bottom, you will click on indefinite leave to remain, calculating continuous period of time. On this guidance, this was updated on 23rd December 2022. This is the updated version. You go down, look for 180 whole days absence. The guidance says no more than 180 days absences are allowed in a consecutive 12-month period. You must only include whole days in this calculation. Part days absences, for example, less than 24 hours are not counted. So if you arrived at the airport less than half a day, it won't be included. Therefore, if the applicant had a single absence during the 12-month period and arrived in the UK on day 8181, the period would not exceed 180 days. Further in this guidance, if you look for calculating the specified continuous period, applicant can submit a settlement application up to 28 days before they reach the period end of 5 years. You must calculate the relevant qualifying period by counting backward from whichever of the following is most beneficial to the applicant. The date of the application, the date of the decision, any date up to 28 days after the date of application. Now let's discuss the holiday period, because many applicants get confused that I was spending time for the holidays outside the UK. Why is it getting included or excluded? So let's see what the guidance says. For all other categories, absences must be consistent with or connected to the applicant sponsored or permitted employment or permitted economic activity being carried out in the UK. For example, business trips or short secondments. This also includes any paid annual leave which must be assessed on a case by case basis and should be in line with the UK annual leave entitlement for settled worker. Now, what is that? For example, the statutory leave entitlement is 5.6 weeks. Paid holiday each year, for which workers who work 5 days a week is 28 days paid leave. However, many employers provide 25 or 30 days paid leave a year, plus bank holidays, short visits outside the UK on weekends, or other non working days are consistent with the basic of stay and do not break the continuity of the leave. You must count such absences toward the 180-day limit. This is very important for ILR count calculation. Evidence in the form of a letter from the employer which sets out the reason for the absence, including annual leave, must be provided. Where short visit outside the UK on weekends or other than non-working days have taken place, evidence from the employer should be provided to confirm the applicant's normal working pattern and show the absences occurred during a non-working period. However, time spent away from the UK for extended period, particularly if the business no longer exists, should not be allowed. Now let's discuss the reasons. So they have provided a guidance absences for serious or compelling reasons. Evidential requirement. Serious or compelling reasons will vary but can include serious illness of the applicant or a close relative, a conflict, a natural disaster, for example, tsunami, etc. The applicant must provide evidence in the form of a letter which sets out the reason for the absence with documents of support. For example, medical certificates, birth or death certificate, evidence of disruption to travel arrangement. They have also provided if in case of the humanitarian crisis. So for example, on 11th January 2018, the immigration rule were amended to discount any absences from the UK from counting towards the 180-day limit, where the absences was due to applicant assisting with the national or international economic or humanitarian crisis such as Ebola. So if you have the evidence, it's very important. They have also cleared about the employment outside of the UK. This is very important because many applicants think that they will get the IT job over here. They will go back to India and they will work from there. They won't be bothered. So if they will come to know, it will be secondary employment and your case will be in big problem. If the absence are connected to underemployment outside the UK, which demonstrate the UK employment is secondary, these are not permitted absences and the continuous period required is broken. Absences due to employment, whether related to the applicant job in the UK or not, counts towards the 180-day maximum each year. Home Office also have provided in the same guidance exceptional cases. I'll put this PDF file in the description. It's version 22 and you can download this file from the description, and this is basically what I have just, so this is the PDF format. So I'll put that in the description. You can download and use it. In the exception, they have mentioned about the serious illnesses, conflict, natural disaster, time spent overseas due to pregnancy, maternity, paternity, parental leave, adoption, or illness is treated the same way as any other absences, that is within the 180 days in any 12 months. So they have provided all the explanation. So if you have any questions regarding this video or any other video, feel free to contact me. You can email me at dr_khan@consultant.com.